Hello everyone, myself Mansi, Asija, and I'm working with LEXIS and Company. And today's topic is part B, journal exceptions, and I'm uh, here discussing from section 92 to 106. First, section 92 is act done in good faith for benefit of a person without consent. Nothing is an offense by reason of any harm which it may cause to a person for whose benefit it is done in good faith, even without that person's consent, if the circumstances are such that it is impossible for that person to signify consent. If the circumstances are such that it is impossible for the person to signify consent, or if that person is incapable of giving consent and has no guardian or other person in lawful charge of him from whom it is possible to obtain consent in time for the thing to be done with benefit. Act done in good faith for benefit of a person without consent. Nothing is an offense by reason of any harm. Got it? Now, move forward to section 93. What is 93 section? Communication made in good faith. No communication made in good faith. No communication made in good faith is an offense by reason of any harm to the person to whom it is made, if it is made for the benefit of that person. Let's take an example. A doctor in good faith tells the wife that her husband has cancer and his life is in danger. The wife died of shock after hearing this. The doctor will not be liable because he communicated this news in good faith, not in not to harm someone. So this is section 93. What 94 section says: act to which a person is compelled by threats. Duress under section 94. Act to which a person is compelled by threats, except murder and offences against the state punishable with death. Nothing is an offense which done by a person compelled to do it under threats, which at the time of doing it reasonably cause the apprehension that instant death to that person will otherwise be the consequence, provided the person doing the act did not of his own accord or from reasonable apprehension of harm to himself, short of instant death, place himself in the situation by which he became subject to such constraint. Let's take an example. A was caught by a gang of decades and was under fear of instant death. He was compelled to take gun and forced to open the door of house for entrance of the cats and harm the family. Then, in this case, A will not be guilty of offense under duress. Okay. Now, next section, section 95. Act causing slight harm. In this section, nothing is an offense by reason that it causes or that it is intended to cause, that it is known to be likely to cause any harm, if that harm is so slight that no person of ordinary sense and temper complain of such harm. Um, in this, let's take a quick case law. Mrs. In case Vida versus Khan. In this case, during the course of exchange of high tempers and abusive words between appellant's husband and the respondent, the latter threw a file of papers at the former, which hit the appellant, causing a scratch on the elbow. In this case, Supreme Court said that the harm caused was slight and hence not guilty. In this, Section 95 will be applied. Now let's start private defense from section 96 to 106. Let's take an okay. Huh. Uh, in section 96, things done in private defense. Nothing is an offense in which a person harms another person in the exercise of private defense. Let's take an example. Uh, this is A and this is B. A does an attempt to murder to B. Then, in private defense, A murder D. Then, murder is an offense, but A is not charged any punishment because in private defense he murdered the D to protect himself, right? Then section 96 will apply. Now take section number 97. Uh, let's talk about 97 section. Right of private defense of body and property. Every person has a right to private defense, provided under reasonable restriction under section 99. First, protecting his body or another person's body against any offense in which there is a danger to life. Second, protect, protecting his or another person movable or immovable property against any offense like theft, robbery, mischief, or criminal trespass, or an attempt to commit theft, robbery, mischief, or criminal trespass. For example, a father, in order to protect the life of his daughter from the attack of a thief, shoots him in his leg. But the father, in this case, but the father will not be liable as he was protecting the life of his daughter. Okay. Uh, let's talk about section 98. Right of private defense against the act of a person of unsound mind, etc. In previous parts, you have read about section 76 and 79, that is, person acting under mistake of fact. And you read section 82, child protected via dolly in capex, right? In section 83, you have read child of immature understand. And section 84, insane person. And in section 85, person non voluntary voluntarily intoxicated. In this case, section 98 will apply. If a in the this 5 points, section 98 will apply. Okay. Let's take an example. A attempts a attempt to kill Jed under influence of insanity, but in this case is not guilty. Why? Jed can exercise private defense to protect himself from A. That's why here section 98 will apply. Now section 99, acts against which there is no right of private defense, right? Hmm. In this restriction, in this section, it talks about restrictions. There's first restriction. There is no right of private defense against an act which does not reasonably cause the apprehension of death or grievous hurt if done. Second, attempted to be done by a public servant acting in good faith under color of his offense, though that act may not be strictly justifiable by law. Third, there is no right of private defense against an act which does not reasonably cause the apprehension of death or of previous hurt if done, or second, fourth, attempted to be done by the direction of a public servant acting in good faith, or under color of his office, though that direction may not be strictly justifiable by law. Fifth point, there is no right of private defense in cases in which there is time to have recourse to the protection of the public authorities. Sixth, the harm caused should be proportional to that of imminent danger or attack. This is the section 99. These are the restrictions in section 99. This section is important. Now, section 100. When the right of private defense of the body extends to causing death. In section 100, it's talk about when you can cause death while exercising private defense of body. Uh, in this case, there are some points. First, assault causing reasonable apprehension of death. Second, reasonable apprehension of grievous hurt. Third, committing rape. Fourth, unnatural lust. Unnatural lust means that in rape, only women's rape or girls' rape is there. In unnatural lust, boys or men's rape is includes. That's this in girls' case, rape is called, and in boys' case, unnatural lust is called kidnapping or abducting, wrongfully confining a person in which that person reasonably apprehends the assault and not able to contact public authority. Last, act of throwing, attempting to throw acid causing apprehension of in the mind that assault caused grievous hurt. This is added by Criminal Law Amendment Act in 2013, Nirbhaya Act. You all remember this Nirbhaya case. That's why this point is added in section 100. Just remember that. Um, let's talk about section 101. When such rights extend to causing any harm other than death. If the offense, if the offense be not be not of any of the descriptions enumerated in the last preceding section, the right of private defense of the body does not extend to the voluntary causing of death to the assailant, but does extend under the restrictions mentioned in section 99. Just remember that the restrictions mentioned in under section 99 to the voluntary causing to the assailant of any harm other than death. Let's move forward to section 102, commencement and continuance. Uh, and continues the right of private defense of the body. The right of the private defense of the body commences as soon as reasonable apprehension of danger to the body arises from an attempt or threat to commit the offense, though the offense may not have been committed. It continues as long as such apprehension of danger to the body continues. Let's take an example. A, B, C, and D. A, B, C were chasing D to kill him in order to take revenge. But suddenly, एक पुलिसमैन ने आते हुए देख लिया. वो डर गए और वापस भाग गए, मतलब दौड़ने लग गए उसके बाद. But in this case, in this example, D shoots B in his leg. Even there was no imminent danger of harm. D will be liable as there was no apprehension of death or risk of danger. Okay. Uh, let's talk about section 103. Yeah. When the right of when the right of private defense of property extends to causing death. In first, robbery. Second, housebreaking by night. Third, mischief by fire committed on any building, tent, or vessel, building, tent, or vessel used as a human dwelling or a place for the custody of property. It mentioned in the uh, Bear Act. Read this. Fourth, theft, mischief, or house trespass under such circumstances as much as may reasonably cause apprehension that death or grievous hurt will be the consequence if such right of private defense is not exercised. Section 103 justifies killing the aggressor and exercise right of private defense in cases of robbery, housebreaking by night, theft, mischief, or house trespass, causing apprehension of death or grievous hurt. This right is subject to two limitations mentioned in section 99. First limitation is that there should have no time to approach and seek the help from the public authorities. The second limitation is that the act of the assailant should not exceed the right of private defense and in no case extend to the inflicting of more harm than it is necessary. It is necessary to inflict for the purpose of defense. Okay. Uh, Now let's talk about section 104. When such right extend to causing any harm other than death. If the offense, the committing of which or the attempting to commit which occasions the exercise of the right of private defense, be theft, mischief, or criminal trespass, not of any of the description enumerated in the preceding section, that right does not extend to the voluntary causing of death, but does extend subject to the restriction mentioned in section 99. I'm again saying, remember section 99. It's an important section. To the voluntary causing to the wrongdoer of any harm other than death. Section 104 explains the circumstances when the right of private defense of property extends to causing any harm other than death. This section also has the same limitations, same conditions laid down by the section 99. Okay. Now section 105, commencement and continuance of the right of private defense of the property. Section 105 explains that the right of private defense of property commences when a reasonable apprehension of danger to the property commences. In this section, the right of private defense of the property against theft continues till the offender has effected his retreat with the property, or either the assistance of the public authorities is obtained or the property has been recovered. The right of private defense of property against robbery continues as long as the offender causes or attempts to cause to any person or hurt or wrongful restraint as long as the fear of instant death or instant hurt or if instant personal restraint continues. Okay. Now, section 106, right of private defense against deadly assault. When there is a risk of harm to, to innocent person. Section 106 what says? That if in the exercise of the right of private defense against an assault which reasonably causes the apprehension of death, the defender, the defender be so situated that he cannot effectually exercise that risk without risk of harm to an innocent person, his right of private defense extends to the running of that risk. This is all the uh, sections of private defenses, and this is the external exceptions of the IPC. Just remember that. I hope so you will love this video, and thank you so much, and just subscribe this channel and this video. Thank you for the thank you for watching this.